so we'll get started. Again, welcome for all those that could arrange their affairs to be here today. Uh, I know this is a crazy time in Texas, and this this presentation is just about Texas. So we're going to record it for those of you that can't, that couldn't join. Uh, but for those that were able to make it, then you'll be able to ask questions and get live answers. So thank you, welcome. Okay, so let's get a few things out of the way. The first thing is pizza. Pizza, this is a lunch and learn. So we've arranged for all those in attendance to get pizza from Domino's. Domino's is an amazing success story, how they went from really doing things not so well to being great now. And so we've arranged for everyone to get pizza. If you didn't get your pizza card to order your pizza or a voucher to get your pizza heading your way for our lunch and learn, you can email Jessica, that's Yessica, like Jessica, but with a Y, Jessica at Rekey.com. Let her know that, hey, I need help getting my pizza. And we'll do what we got to do to get pizza heading your way. I think that's a unique thing with this online lunch and learn. So I want to make sure everybody gets their pizza. Great. Okay. Let me tell you about the topics we're going to cover today so that you can see that the time you're investing in this class is worth it. So the first topic. What? Oh, I'm supposed to go to the next slide. Sorry. So here are this is about the pizza. I forgot to move slower. There you go, the pizza and the email to order your pizza if you didn't get it yet. And now we're going to move on to the 4 things we're going to cover in today's class. We're going to cover 4 ways to protect yourself legally. I think that's the real meat of this presentation. We're going to talk next about common misunderstandings and mistakes of the Texas Property Code, and then things you may not know about the Texas Property Code that could be helpful. And we're going to share some professional recommendations on dealing with the Texas Property Code. And then finally, we'll conclude with a question and answer session. But even though we're going to conclude with that, you can ask questions all along by typing in your questions in the Zoom box there. And we can address those as we go as well. All right, so that's what we're going to cover. Let's move on. I hit the wrong button. All right, now I was going to mention this. What makes me qualified to be an expert on this topic? Well, 2 things happened 25 years ago. 25 years ago, the Texas Property Code went into effect, right? Can't believe it's 25 years. But for those of you that have been in property management and real estate for more than 25 years, you'll remember when this change happened. Something else happened in 1995. We started Mr. Rekey, and I've been running Mr. Rekey for 25 years. And during that time, during those 25 years, we have brought more than 1 million homes up to Texas Property Code. Now, of course, we've rekeyed several million homes, but 1 million homes were brought up to code through Mr. Rekey. Now, during this time, something interesting happened. We had been involved with or dragged into or consulted on about just slightly over 50 lawsuits. And the interesting thing, none of these ever went to court. And I'm really proud of that. And I think what I'd like to do is share with you some of the things that we used to defend our property managers so that none of these events went to court. That's a little picture of the zillions of blocks we did. So protect yourself legally. Number 1, first of all, and here's the shocking thing, you may already know this, but laws can be very vague, right? In the Texas Property Code, there's many things that are alluded to, but not completed. There's not enough data. There's not enough information. Take, for example, the city of Austin, who enacted a requirement 2 years ago for CO detectors, right? coincidentally, this is the time where that has really been effective. But anyway, because a lot of people, we'll talk about what's happening in the CO department here in a little bit, but why it's confusing is the requirements, the written requirements, the actual statute says one thing. The website says something else that's slightly different. And then the city of Austin published a video to explain the law, but then again, it's different than the website and different than the actual written law. So which one do you follow? And so that can be really confusing. Well, you always follow the written law, but when you're given a video from the city or something on a website, you tend to think that's pretty spot on when really it's not. So here's what you do. Number one, the number one thing that you need to learn in protecting yourself legally from all of the crazy misconceptions of the Texas Property Code, the number one thing you can do, and if you're taking notes, you should write this down. It's called common acceptable practice. I highlighted it on the screen. Common acceptable practice. What does that mean? Well, if in your country, state, city, whatever this jurisdiction is of any potential lawsuit, the question that you can use is what has commonly been done from all people, all realtors, all property managers in this space, right? What's the common acceptable practice? And if you have that, that's a great defense to use if you go to court. Now, fortunately, we've never gone to court because once we showed what was the common acceptable practice, things kind of evaporated. Well, when you're responsible for, Mr. Rekey has done 1 million homes throughout Texas, in Dallas, Fort Worth, San Antonio, Austin, Houston, so forth. When you've done 1 million homes, you've kind of set a stage for a common acceptable practice that we can point to and say, this is what's been done across the state and this has worked. Okay, great. So that's number one, to protect yourself. Remember that, common acceptable practice. And that's true, not just in the Texas Property Code, not just what I'm talking about today, but really in any lawsuit that you ever find yourself in, remember that term. Okay, number two, way to protect yourself. Also on the screen here, it's called standardized policies. Standardized policies. What do I mean by that? If your company has a standardized policy that's written out that you follow in all of your properties, you've done the same thing in every single property, this is your policy, this is your standardization, then it makes it very hard for a lawyer to pick you apart, right? What a lawyer on the opposing side is going to try to do is get your, let's say, maintenance guy on the stand or even the property manager and try to shake you up by saying, well, you did that here, but did you do that there? Are you sure that you did it in every property? Did you do this? Did you do that? So they're going to try to pick apart what you did in your decisions. But when you have standardized policies that you follow, it's very difficult to pick that apart, right? All right, number three. I find that using a third-party contractor in areas of liability is a wise choice. Now, I know that sounds like a shameless plug for us, but it doesn't have to be Mr. Rekey. It could be any company that you use, as long as they follow a few things. Now, how is it that as a third-party contractor, we've been able to protect our property management and real estate clients? Well, we've been able to protect them because it's sort of like having the ultimate alibi. If you're accused of a crime and it's determined and proven that you were 8 states away at the time that that crime was committed, you've got a pretty good alibi, and most likely they stop looking at you as a suspect, and your problem there goes away because you have a great alibi. The same works with a third-party contractor. When you can say that I've used this third-party contractor and I'd like to bring them into this conversation, then it's like having the perfect alibi, because now a third-party contractor steps up to the plate, says, these are our standardized policies, these are our acceptable practices, and you have documentation from a third-party vendor, then the lawyer can't really pick that apart. They know that they get you on the stand, that's pretty much it. Their case is going to dissolve. So using a third-party contractor is your third way to protect yourself. And fourth, and I kind of alluded to this already, is documentation, right? Just document everything. Documentation is a wonderful way to protect yourself. It's one of the things that I think a lot of our clients like about what we do is that our software allows our tech in the field to take pictures of all the smoke alarms, to take pictures of the components to the Texas Property Code. That's the one-sided deadbolt, the door viewers, Pinlocks. Those pictures are then recorded and they can protect you, right? Documentation. I had one case where a fire and smoke alarms, and when we were able to show to that lawyer, the opposing lawyer, that we had documentation from 4 to 5 times of being at that property and checking those smoke alarms and validating they were in good working order, that case dissolved right then. And that's good because the guy was a bit of a scammer, right? He was looking for something more than that they should have had. Okay, so again, just a quick note here showing some of the questionnaire that we ask our techs to fill out so that they're crystal clear on everything that they did at that property. Here's a sample of some of the pictures that we've taken at the properties showing that we do sometimes take pictures of more than just the locks, right? If we see something else that is beneficial. So again, documentation, you see pictures of smoke alarms, validating the smoke alarms are there. And this is important because tenants will take smoke alarms down. They will take smoke alarms out, sadly. And because of that, you want to show that those smoke alarms were indeed in the property and operating at the time. All right, let's see. Again, more documentation pictures. All right, so the question comes up, all right, Ken, what happens if I don't bring a property up to code? Is it really that bad, right? Well, that depends, right? I can tell you that I've seen more cases recently because what happens is tenants now are becoming more and more informed as to what their rights are. You know, we have organizations like the Austin Tenants Council that is always there as a resource to let tenants know this is what you can do if your property's not up to code, right? And there's more people over these years that have become more aware of what the requirements are. So what can happen? Well, if you don't bring the property up to code, first of all, tenants can break their lease, no questions asked. If it's determined that that property is not up to code, doesn't have the necessary components, they can walk away from their lease. It's in the law. It's not up for dispute. There's nothing you can do. It's in the law. Says they can unilaterally break their lease. What's another thing they can do? Well, they can decide to stay in the house and then arrange for a third-party contractor to bring the property up to code. And whatever that fee is, whatever that contractor charged to bring that property up to code, they get to deduct it from their rent. Again, no questions asked. There's nothing you can do about it. There's no way to dispute it. It's in the law. They automatically get to deduct that from their rent. And really, there's no way to know if they're charging you unless you get a copy of the invoice, what's fair and reasonable, right? And it could easily wipe out, let's say, a whole month's rent. They also, if they start challenging it, they also can get attorney's fees, plus $500 if they decide to take it to court. My experience has been not only can they just get legal fees and the $500, but once an attorney actually files suit, attorneys, for the most part, in my experience, will make the case as big as they possibly can and will ask for ridiculous amounts of money, monies that are not laid out in the Texas Property Code under remedies, right? They'll try to go for as much as possible unless, I guess, those things get challenged, right? So those are the kind of things that can happen if you don't bring it up to code. So you're trying to bring it up to code, you're trying to do the right thing, but unfortunately, there's some missing things, there's some confusing items, and there's some impossible things in the Texas property code. What are they? Well, let me share one with you. Common misunderstanding or mistake in the Texas property code has to do with door viewers, right? Okay, door viewers. What's an acceptable height for a door viewer? You know, well, in the Texas property code, it doesn't tell you where the door viewer should go. It doesn't tell you how high it should be. It doesn't give you any height. There's just nothing there. It's void. So what do? Well, that's when you revert to what we were talking about earlier, a standardized policy. What's your standardized policy for what the height is of where you put a door viewer? Well, for our company, for many years, we were going with 60 inches. We picked that up from another state's requirements, and we went with 60 inches. But later on, we found that 60 inches was not the best height. We found that 58 inches was truly a better height. It was a height where the most people could see out the door viewer. So we changed our policy, and some property managers did this as well. And we said 58 inches is what we're going to go with from now on. So you will find that for our company and many of the homes we do now, they're at 58 inches, standardized all the time. Let's look at another confusing thing. And this has been really confusing. It has to do with pin lock. There's a picture of the pin lock right there. So the pin lock has to be installed in a door. There are three things mentioned in the Texas property code concerning glass sliding patio doors, right? And the three things that are mentioned are pin lock, a working latch, and a Charlie bar. So just to make it simple for you, the law requires a pin lock in every glass door, right? The Charlie bar and the latch works this way. If you have the pin lock and you have a working latch, you meet code. If you have a pin lock and your latch is not working for whatever reason, which is common with patio doors, latches do break, you can use a Charlie bar in that case, okay? But the pin lock is always required. Here's the tricky thing about pin locks, and I hate these things, but they're required, so we have to do it. Pin locks cannot be installed in the place that the Texas property code says that they're to be installed. Let me repeat that. You cannot install a pin lock where the Texas property code wants you to put it, at least not the type that they refer to. Now, there are other pin locks that you can put it in that spot, but not the way the Texas property code lays it out. Reason is, the Texas property code says it has to be in the center and it has to be 36 inches high. Well, what's wrong with that spot? Well, in that spot, if you had x-ray vision and you could look inside your patio door, you would see that the two pieces of glass overlap at that point. They have to overlap, right? They have to overlap to provide the door to seal, right? Because there's two frames that have to interlock together on the patio door, which means the glass overlaps. And if you try to put a pin lock there, it's going to go bad. You're going to break the glass and be disappointed that you weren't able to do that. So what have we done in that situation? Well, we have mounted the pin lock exactly as law requires, but we mount it at the bottom of the door. We meet all of the intention of the law, which is important, right? We meet all the intention. We met a lot of the requirements. The only thing we couldn't do is the 36 inches. How do we propose to protect ourselves on a law that can't be done? Well, it goes back to what's the common accepted practice throughout the state. What have we done on a million homes, right? What makes sense? What is our standardized policy? This is what we've followed, and we haven't had a problem in 25 years. Again, I wish they'd do away with the pin lock, but this is here to stay for now. Now, I also take this moment to say I think Charlie bars are a great idea, right? Uh, I recommend that people put them on anyway because they act as a visual deterrent to people trying to get in the house. Many times burglars will try to jack the door up and down. They'll try to pry different things. But when you see the Charlie bar, it pretty much says you're not going to get in through that door unless you break it, right? Um, but going back to the requirements, I said pin lock and then either a working latch or a Charlie bar. I also recommend, it's my professional recommendation, to always fix the latch. The latches are always repairable. I don't care what anyone else says, they can be repaired. There's a number of suppliers out there that sell replacement patio door handles, and there's some generic ones that work in just about every case. The advantage in repairing the latch is that versus just putting a Charlie bar on. The advantage in replacing the latch is if you don't repair the latch, every tenant that moves in is going to complain that the latch doesn't work. And you don't want to be in a situation where you're constantly explaining, yeah, the latch doesn't work, but we put a Charlie bar on, you're fine, right? Just fix the latch. That would be my recommendation there. And we've certainly have helped people do it. Here's a picture of a Charlie bar. Again, as I said before, I highly recommend putting them in as they act as a visual deterrent. Okay, so I'm not going to get into a lot of the nuts and bolts of the specific law because that's a class in itself. But let me just run through some things very quickly of what's required. I'm going to talk about number 3 here on the screen. That is the one-sided deadbolt, right? You see a picture of it there. A one-sided deadbolt is a deadbolt that is just has a thumb turn on the inside and nothing on the outside or just a plate on the outside. You have 3 choices to fulfill that need. You can go with the one-sided deadbolt that you see here. You can go with this ring bolt that's in white that you see here. And you can also go with a bar across the door. Now, my recommendation in this case, if you have to do one of these 3, is to always go with the one-sided deadbolt. It might cost a few dollars more than the ring bolt, but I think it looks the best. The hardware can be matched color-wise to what's already there, and all you're really adding to the door is just this little thumb turn. If you add the ring bolt, you choose that option. Here's the problem with the ring bolt. Here's one in my hand right here. You can see that when they're hanging from their mounting bracket, right? When they're hanging there, they get dinged around, they bang the door, they get caught in the door, they jam a door, and then tenants get tired of playing with this thing every time they go in and out their door. And what do? They take it off and throw it away, and next time around you got to buy another one and you start the process all over again. That doesn't really happen with the one-sided deadbolt. And also, when we're talking about acceptable practice, more homes by far, I mean, it's literally 99 to 1 have the one-sided deadbolt versus the ring bolt. Now, I have really good clients that prefer the ring bolt, and that's fine if that's what they want to do. We're going to always do what our clients want us to do, and we're happy to put these ring bolts on. It's just not my recommendation, right? Now, here in my hand, I have I don't know if you can see this. This is a sort of a mock-up of a door. It shows the knob deadbolt and the one-sided deadbolt here. You can see thumb turn on this side, nothing on the outside. Unfortunately, the graphics get lost when I try to show that. But again, just to recap, you got a one-sided deadbolt, you have the ring bolt, and you have a bar. Now, you might say, a bar across the door, now that would be the ultimate and ugly. But it's really not. And I'm going to show you a picture in a minute of a hook that somebody else did to do the bar. But generally what happens is the bar doesn't really stay on the door. All you're doing is putting a hook on each side of the door to hold the bar, but then the bar is usually stored in a closet. Now, why would you do this? Well, there are going to be times where you just can't drill into the door, or you just don't want to drill into the door. And when you see this picture of the bar hooks, you'll get the point that I'm trying to make. It's something that is really not that obtrusive at the end of the day. When the tenant leaves, it's easy to fill in those holes, and you'll never know that this house had ever been a rental. Okay. Also in this picture, I show that the door viewer there. Another common misconception about door viewers, since we were on the topic there, is where are they needed, right? Well, they are needed on every exterior door that does not have a solid piece of glass that is clear. So if it's a solid frosted glass, it still needs to have a door viewer. If the window is too high, it has to have a door viewer. Some people have said, well, Ken, I got a window, clear glass window right next to the door, and it is even part of the overall door frame. Do I need uh, a door viewer on that door? Well, perhaps not because it's part of the door frame, but the law says it's got to be in the door. And I wouldn't want to have to argue that later. So my recommendation is door viewers are inexpensive. Just put one in. Make sure that you've covered all of your bases by putting in an inexpensive door viewer. Another common question about door viewers is, are they needed on the door from, let's say, the kitchen to the garage? Are they needed there? And the answer is yes, they are. There is not an exception to the door going to the garage. The law is very clear. All doors leaving basically the living area, all doors, all exterior doors, and that's considered an exterior door, have to have the door viewer. But before you bristle at the idea of putting a door viewer on the door to the garage, consider this other point, um, where there have been cases where a tenant left their roll-up garage door open, right? And they're inside the house, and a nefarious person walks into the garage with the intent of taking what they can. But before they do, just to cover themselves, they decide they're going to knock on the door just to see if anyone's there, right? So they go and they knock on the door. But since there wasn't a door viewer, what happens with the homeowner? Well, they just open the door and take a look. And now they find themselves face to face with somebody they don't want to find themselves face to face with. So again, my point is door viewers are so inexpensive. Just put it in that door, meet the code. Don't give tenants any opportunity to challenge that your property was brought up to code. Um, Final picture here is a keyed lock. Yes, all doors are supposed to have a keyed lock. That can be a knob or a deadbolt, but at least one door has to have a keyed deadbolt. And that's practical so that a tenant can leave the property and lock a deadbolt. If all you had was locking knobs, that's no security at all. And they wouldn't be leaving their property secure while they were gone. So my recommendation is use a passage knob, have a keyed deadbolt on every door, and a one-sided deadbolt to meet the Texas property code. That's my recommendation. But at the very least, have the locking knob, have the one-sided deadbolt, and then make sure at least one door has a locking deadbolt, and you will comply. You're probably wondering, why do I call them one-sided deadbolts instead of keyless deadbolts, right? Well, the term is sort of interchangeable. When the law was written 25 years ago, keyless deadbolt meant any deadbolt that didn't have a key. But today, and we're going to look at some pictures of some, today, many people have gone to Home Depot and Lowe's and got a push button electronic lock so they don't have to carry a key with them. And this is quite common now, more than ever. We're seeing this in just about every home where they've got a push button lock. So we refer to those as keyless. And the one you're looking at in the picture with the thumb turn, we consider those one-sided because that is the locksmith industry name. I think the Texas Property Code, when they wrote it, they just wrote keyless deadbolt, not knowing where we were going, but their description in the law describes the one-sided deadbolt to a T. Okay, great. All right. Let's see, now I'm moving on here. When I talk to you about the bar, this is a case where, you can see in this picture, where somebody decided to put the bar across the door instead of a one-sided deadbolt or a ring bolt. If you look at the picture in brown, the one with the brown door, you can see that all they've done there really is put two hooks, one on either side of the door. Now, those are big hooks. I'm not recommending that you put those big old hooks on. They're not even required. There's no size mentioned in the Texas Property Code of how big that bar has to be. But by simply installing those two hooks, one on each side of the door, and putting the bar inside of a closet that the tenants can use whenever they want to secure that door from a landlord entering the property, you've met code. So in certain doors, we've had to recommend that because there's no way to put a ring bolt or a one-sided deadbolt there because maybe it's a steel door that is hollow, ornate. It just wouldn't make sense. Maybe it's one of those three-point locking doors from Europe style that there's just no way to put a one-sided deadbolt on that, right? Now this one shows the bar, but again, you can take that bar off and leave it somewhere else in that silver one there. So the bar, as distasteful as it may sound, is really not that bad, and we have had clients that have had to do that. Again, when I was talking about protecting yourself, documentation is such an important part of that. And we're going to talk some more about smoke alarms, but these are some pictures of smoke alarms. We may have to, let's talk a little bit more about smoke alarms since we've got a couple slides right here. First of all, most homes do meet the requirements today for smoke alarms. And the reason is that long before the Texas Property Code, the building code started requiring smoke alarms, and the Texas Property Code basically followed what the building code had done. So any homes built since probably 2000 have all the necessary smoke alarms. And we're going to talk about what's needed. There are two main ones that are out there. There's the wired in one, which is what's required. And then when the home is older and you can't put a wire, there's just no way to put a wired one in, you can, but then you're going to have to get an electrician to come out and do it. The law does allow you to put in a battery operated one in those cases, right? Now, if you do any remodeling work to the house, you will have to put in the wired smoke alarms. What we do for our clients is to help them make sure they're meeting code is this handy little device here. I don't know if you can see it very well. This is a smoke check device right here. Now, a lot of people feel that as long as they push the button and the smoke alarm beeps, that they've met the requirement there. That's not really true. All that the beeping, if you push the red button, all you're doing is just identifying that smoke alarm has power, it has juice. It does not tell you that smoke alarm is in good working order. The only way to truly determine whether the smoke alarm is in good working order is with the device I was showing you earlier. To try it with smoke, spray some smoke on it and make it go off. Now, my recommendation for property managers is in their homes, they should replace their smoke alarms every 10 years. And I say that because that's what the National Fire Protection Association recommends, right? And they have been working with cities and states all over the country to try to create this as a standard that you replace them every 10 years. I personally feel that it shows that if a property manager, heaven forbid, should ever have a fire in their property, the standing in front of a judge and being able to say, hey, we've always replaced our smoke alarms at the 10-year mark is smart. And they've got some out now, these lithium ones that last 10 years. I mean, you put these in and they're good for 10 years. 10 years of not having beeping batteries or anything is pretty amazing. So that's my professional recommendation, to always, this is a fire that just happened yesterday, by the way, sad. We're going to talk a little bit more about that. Another professional recommendation that I have is have a fire extinguisher. This property did not have a fire extinguisher and the fire got carried away very quickly. you know, you never know when there's going to be a kitchen fire. It's the number one place that fires break out. And, you know, if you get a grease fire or something else catches on fire in the kitchen, being able to grab a working fire extinguisher and spray that fire and put it out right then is just practical. As a property manager, your job is to protect this property, the value of this property, and your job is to protect the tenant. I feel like if you don't have a fire extinguisher, are you really protecting the property and really protecting the tenant? Fire extinguishers last many years. They're inexpensive. I just think it's wise to have it. That's my professional recommendation. The Texas Property Code says if you put one in, you have to make sure that you monitor it. But if you put one in, like I said, they last 5 years. So I highly recommend them. Let's see what else we have here. Of course, I showed you how we check with smoke. There's a picture right there. We have many clients that have us put batteries in all of their smoke alarms whenever we do the rekey during turnover, right? You don't have to do that. But you know, you can have your maintenance guy do it or whatever. It's just something that we have done, and we put little stickers on all of our batteries that state when that battery was put in. And I think it's a great way just to prove, again, that you did everything that you could do for tenant safety. And I love my little stickers on there. Okay, so and you want to avoid, when you're going to show the property, if you're still showing it after the rekey, of having chirping batteries going off, or having a new tenant go in and want or complain about chirping batteries. Okay, these are some headlines. We're going to talk a little bit about CO detectors also, because this is sweeping across the country. Here are 3 headlines that happened to last night and today. I'm going to repeat that. These are 3 headlines that happened last night and today. For all of you that have worked hard to get all your properties up to speed with CO detectors, I applaud you, because this is the time that you did that for. This is the very circumstance. People today, you know, if you're not aware, you know, here in Texas, we are covered in ice and snow all across the state. And the worst part about it is the electricity is down. The electricity is down all across the state. So what's happening? People are using their fireplaces. That creates CO. People are heating themselves in their cars, right? There's actually people, I don't know what they're thinking, that are heating themselves in a car in a garage. That's how people commit suicide. And yet they're doing it just to keep warm, unaware that they're doing something that people have done for many years to commit suicide, by getting in a locked car or getting in a car in a garage with the engine running. But that's been happening. And that CO goes into the house. And it's not just those. People are looking for all kinds of ways to stay warm without power. And they're bringing in, you know, kerosene heaters, and they're bringing in camping heaters and all kinds of things into their house. And this is a dangerous, dangerous time. So as I said, if you got ahead of the game, you brought your properties up to snuff with CO detectors, good for you. In the city of Austin, it's been a requirement for 2 years. For 2 years, as I was mentioning earlier, to have the CO detectors. It's been confusing, as we mentioned earlier, but many property managers in our city of Austin or in San Antonio already started putting CO detectors in their properties even before it was required. So I highly recommend thinking about that. And of course, we've done this for a long time. So again, we have our policies and procedures as to where CO detectors should go. And we've seen many companies now follow our lead on placement of CO detectors. So we can certainly help with that. Okay, we're gonna shift gears here a little bit, and we're gonna talk about some things you may not have known about the Texas Property Code. Okay, great. So I've already used up 40 minutes of your time. I'm gonna try to leave some minutes for questions, but let's talk about this first one. There are exceptions to bringing a property up to the Texas Property Code. What are those exceptions? If your resident is 55 years or older, if the whole building is mostly 55 years or older, you don't have to bring the property up to code. If the person living there has a mental disability, if they have a physical disability, or if they have a situation that requires them to have checkup visits. Let's say, maybe it's an elderly person or someone that's had other health problems, who knows, that require regular checkup visits from a professional. You do not have to bring it up to code. Now, I recommend always bring up the code whenever possible. Just because somebody's 55 years older, I'm older than 55, of good sound mind and body. You should, if I was renting a house, I'd say, yeah, you should bring it up to code. You can certainly use that as a reason not to, but how long is that tenant going to stay? Tenants move out every couple of years, new tenant moves in. Sooner or later, you have to bring it up to code. Sooner or later, you're going to have to explain to the homeowner what this expense is that you did. Again, you may not have known this. Here's another thing you may not know, that if a tenant, and this is going to save you some money, if a tenant breaks your lease, right? We've had that, right? That happens from time to time. A tenant will break a lease. If a tenant breaks a lease, by law, they have to pay for the rekey. That's right. If a tenant breaks a lease, by law, by the Texas Property Code, without any question, the tenant has to pay for the rekey. And you can deduct that from their deposit without question and have them pay for it and save that money for the owner of the property. Okay. Here's another thing you may not have known, and it's because it's not in the Texas Property Code, it's in the Texas Occupation Code, right? It's a different code. We know that in our industry, there are all kinds of codes, statutes, ordinances, just rules. There's all kinds of things out there. It's so hard to keep track of everything. But in the Texas Occupation Code, if you charge a homeowner for rekeying, that is, if you change the combination on the door, right? You don't even have to change the key. You're just changing the combination, or change the card access, or change the key. If you charge if you're a third-party property manager and you charge a homeowner for doing those services, you must have a locksmith license. Not everybody knows that. And so, obviously that's a plug for us because we're obviously licensed locksmiths, but not everybody knows that. And I've seen some property managers feel that they can go to the store and buy this or change out that, or get the smart locks, which is great. Smart locks are great, but they'll try to do a program where they're going to change their own locks using smart locks, but they're still charging the homeowner. The smart locks are fine, changing locks are fine. You don't need a license for doing that. But if you charge the homeowner for changing that combination, you have to have a Texas license for that. And that's something not everybody knows, but I felt that I should share that. Here's another thing you may not have known. Full of new ideas today, right? If a tenant goes to Home Depot, Lowe's, whatever, and they buy one of these keypads we were referring to before, not the one-sided deadbolt, but an actual keypad that you punch in a code. If they put that on the door, by law, by the Texas Property Code, that, like these smart codes here, these become permanent fixtures of the property the minute they put it on there, and they cannot remove it when they leave. That now belongs to the house. Now, maybe your policy is, I want them to take it off. I want them to take it with them. I don't want it there. But sometimes this leaves a problem for the property manager, where the tenant went out and bought one, took the deadbolt off the front door, put this on. Now the front door is not keyed to their key system anymore. If you have questions about key system, please reach out to me. But it's not keyed to the key that the landlord thinks the house is on. And then when they move out and they take this smart code, or from Schlage or Kwikset, and they take this keypad off the door and abscond with it, which they weren't supposed to do, Now they gotta find another deadbolt to take its place. They probably lost the original deadbolt that matched what was there. So they run over to Home Depot, they buy some cheapy deadbolt, they slap it on there. Now you still don't have the key to get in, and it does have some problems. So I recommend, my professional recommendation is put this in your lease somewhere along the line. Talk about this is if you decided to change locks, you have to let me know as the property manager. You're required to let me know. And if you put one of these things on, be aware that it has to stay upon your leaving, and we want it keyed to our property system, right? Okay. Let's see. We're almost done here. A common question that I get, really common question from property managers is, when is the best time to rekey? When is the best time to bring the property up to code? And the best time is just before the new tenant moves in. And let me tell you why. Because you only have 7 days to bring this property up to code. And we've found that in trying to book with tenants, some tenants are easy. Yeah, come out, rekey it, bring it up to code, everything goes well. But there is a sizable percentage, and I'm just going to pull it out of the top of my head, like 20% or so actually make it really difficult once they move in to find a time. They keep putting off the locksmith from rekeying the house, and before you know it, the 7 days are up. The locksmith has to call the property manager. We're having challenges. We can't get it. We can't get it with the tenant, and so it just goes back and forth and just takes extra time, extra hassle. Another thing that happens, we get to the property and we're going to do the work, but the doors are blocked by something, or there's a sleeping baby and they don't want us to test the smoke alarms, or they don't want us to go to the back door because maybe there's boxes blocking at our furniture. Or they're moving in something and all the doors are open, and it's just really challenging to rekey when the tenants are there. We're happy to do it, but the best time is to do it ahead of time. And that way you don't have any hassle. It's done. We just put it on the schedule next day or the day before, whenever you want it done. We're out there, we get it done, and we don't have to deal with the tenants going back and forth. All right, so that is all my slides, and we finished everything in about 48 minutes. I think they're going to try to bring me back up here. Great. And now we're at our question and answer part for like the next 12 minutes. I think we have some questions possibly popping up. All right, so one question, great question, Gina. Where do you go to have fire extinguishers checked that they're in working condition? Well, there are companies around, fire extinguisher companies, that will do that for you. However, I would recommend, rather than taking the time and the money to take an older fire extinguisher and take it over there, new ones are really cheap. I mean, new ones are like 40 bucks, right? 20 to 40 bucks, generally speaking. I recommend, rather than the time to go refill them at like AAA Fire or one of those other places, I think the best thing to do is just take the old one out, put the new one in, discard the old one, or get a bunch of them and you can take them all at one time. That's probably the simplest way to handle maintaining them. And again, they last for 5 years. So, I think you're busy as a property manager. That's just one more headache. It may be easier just to swap it out. That's my recommendation. I hope I've answered your question there. All right, great. Great. Any other questions that maybe I didn't address today? You can always reach out to me at any time. My email is ken@rekey.com. So you can always email me there or text me. We have a person live. But Warren, did you want to ask a question?
Yeah, I have a question for you. Um, as far as the 7 day after the tenant moves in, um, we, I'm, my office always does it after the tenant moves in because I believe that's a definition in the property code. So are you saying that I can change the locks prior to a move in?
Yes, you can. I find that probably 80% of the property managers across the state do it in between turnover. About 20% do it after the tenant moves in. If that's your procedure and policy or how you do it, as for us, and I'm sure anyone else you use, we can certainly accommodate that. We're set up to call the tenant. We'll take care of that. But again, my recommendation is to do it during that time frame so that you don't get caught dragging this out past 7 days or forgetting it altogether. We see that happen quite a bit where we get to a property, it's not up to code. We've been servicing this client and this property before. We go in the notes and we find that there was a challenge with the tenant, 2 years ago. And now I'm thinking, oh my goodness, this thing got left undone because all we can do is reach back to the property manager and say, we can't get this worked out with the tenant. And so they let it go. Now 2 years go by. My fear there is during those 2 years, you had that liability, right? So, and then, property managers get mad at me. Why didn't you bring it up to code 2 years ago? Well, we couldn't, right? If it's vacant, we can certainly do that. So the answer is yes, you can rekey before the tenant moves in. Absolutely. It just has to be done, after the old tenant moves out. That's the only requirement. I hope that answers your question. Thank you for participating. I appreciate that. Okay, do we have any other questions? Let's look. Okay, I think that's all the questions. I want to, I know that it was difficult to attend today because of the power outage across the state. For those of you that had power, that were dealing already with all the craziness you're dealing with right now as a property manager, the fact that you took time out to spend this hour with us, we really appreciate it. I'd love for your feedback. This was the first time I've done this particular Lunch and Learn, and your feedback would be really appreciated. Again, thank you for your comments, Gina, and everybody else. And I guess that's the end. So we'll exit. Enjoy the rest of your day. Well, enjoy the rest of your day. It's crazy out there. But thank you again for attending.